Also, remotely from an undisclosed location in the Lone Star State, Judge Higginbotham. Y'all can see him fine, correct? Okay. And Pam, y'all checked out the audio. Everybody can hear everybody? All right. Well, let's get started. We just have the one case today. So, Mr. Dunbar, you want to kick us off?
May it please the court. My name is Jeremy Dunbar, and I represent the plaintiffs' appellants in this case. The Republic of Ecuador's Constitution and laws require a company conducting business in Ecuador to share its profits with its employees. And that means any profit attributable to a year in which the employee performs work for the employer, regardless of what appears on the employer's tax returns. Based on these principles, this court should reverse the district court's order granting summary judgment for two reasons. First, Oxy's failure to declare a profit in its tax filings is not dispositive of its profit-sharing obligations. And second, there are genuine disputes of material fact as to whether Oxy realized a profit that it must share with the plaintiffs.
Just as kind of a housekeeping matter, Mr. Dunbar, we're going to obviously have to rely on Ecuadorian law to some extent, and none of us, although maybe Judge Willett has a secret. That is a strange echo I'm hearing. But I'm going to power through it. Unless Judge Willett is an expert in Ecuadorian law, or maybe Judge Higginbotham is, I know I'm not. So to the extent I need to verify Ecuadorian law, I'm assuming, how do we treat that? As a fact issue, as a legal issue, as a matter of looking to the record and seeing the declarations? How should we approach that issue?
Right, Your Honor. The question of Ecuadorian law is a legal question. It's reviewed de novo. Typically, when a question of foreign law comes up in a district court proceeding, the standard practice is for the parties to submit expert reports on what that law is, which is what we've done in this case. And as our expert testified, under Article 148 of the Ecuadorian Constitution and Article 97 of the Labor Code, an employer must share its profits that are attributable to a given year with its employees that performed work during that year. Which brings me to the first issue, which is that the district court erred when it ruled as a matter of law that tax returns are the exclusive method of determining the profit-sharing obligation.
That leads to my next question, which is, as I take it, the district court looked to Article 104, is it, of the Labor Code?
That's correct, Your Honor.
Okay, now, so where am I going to look to tell whether that's a mistake under Ecuadorian law? If you could be specific as to the report of this expert or that.
Sure. And just to be sure I heard you right, you said, where are you going to look to determine whether that's a mistake?
So the district court says, if I'm not mistaken, look, Article 104 of Ecuador's Labor Code says you look to the income tax.
Right.
And the income tax here, there was a loss declared.
Right.
So where should I look to say, oh, no, that's a mistake?
Sure. In the record specifically at ROA 797, that's our expert report, Dr. Almeida Guzman. And he obviously provides a translation of Article 104, which states that the profit calculation shall be made on the basis of the declarations or determinations prepared for the payment of income tax. And to state the obvious, just textually, looking at Article 104, it simply requires that profits, for tax purposes, be determined based on the profits contained in declarations and determinations made in tax returns. But the National Court of Justice in Cruz versus Chagra Norte recognized that regardless of Article 104, tax returns do not control the separate profit-sharing obligation if evidence of profit separately exists. And
what does Cruz say? The district court addressed Cruz. Is that a case about when tax returns have been established as false? Is that what that case is about?
Yes, Your Honor. Yes.
Okay, so that's a tough one for me because mean, nothing definitively establishes these tax returns as false, does it? In fact, they've been audited and determined not to be false.
Respectfully, Your Honor, we disagree. Whether they were false at the time of filing, that is, whether Oxy was required to report these profits in 2006 when they were, as Oxy says, contingent assets, or whether they were subsequently required to amend them, despite the fact that the statute of repose had run, does not address the pertinent question. When Oxy received this award, which Oxy characterizes as profits, at least in part for 2006, it received a profit and it was required to share it, and its tax returns were effectively rendered false. Whether or not...
Do you have any Ecuadorian cases for that proposition?
No, Your Honor, but I would point the court again to Cruz, which stands, although it did involve a tax return that was shown to be false within the statute of repose, presumably, it stands for the broader principle that when an employer receives a profit under Ecuadorian law, both the Constitution and Article 97 of the Labor Code, it's required to share that profit. And Cruz also stands for the proposition that the court must look at the reality of the income and can, when there's evidence that establishes, or in this case, at least creates a genuine dispute of material fact as to whether there's profit for a given year.
Let me ask you this. So let's assume, for the sake of arguments, that the settlement that ended up being what, $979 million?
Yes, Your Honor. Something like that.
That represents profits to in some way.
Right.
What year's profits would that represent?
Well, I think that's a question that needs to be determined below.
Yeah, but I mean, surely you have a view on that. Right?
Well, I think at a minimum, a portion of it represents profits for 2006.
So a portion. So other years as well.
Correct, Your Honor. I think I can say this. In their arbitration award, they sought the profits that they would have received between 2006 and 2019.
Okay, so that's multiple years. So I guess my question is more of a practical one, that in light of that, didn't they show a loss of something like $700 million in 2006?
I believe that's right, Your Honor.
And didn't Ecuador seize their, what was it, their production facilities? What did Ecuador seize?
I believe that's right. I know at a minimum they terminated the contract and obviously caused Occidental or Oxy to cease all production and exploration activities.
Yeah.
In
that
Ecuador.
was in what, May of 2006?
Yes, Your Honor.
By hypothesis, let's again assume that this award represents in part some profits for the remainder of 2006. Did the employees get anything in 2006 representing the profits, profit sharing?
No,
They
Your
did
Honor.
work some of 2006, right?
No, Your Honor, they
Got
did.
nothing.
No, they were terminated. Oxy declared a loss, and as far as to 2006, they did not receive any share of any profits. And I think your questioning only goes to underscore why this case is deserving of remand. The allocation of the settlement payments in light of the cost to Oxy in 2006 is a highly fact-intensive question, and I suspect that it will require additional discovery or any discovery, some discovery, as well as more expert testimony. The district court in this case disallowed all discovery. The question of how much of this should be divvied up among the years and then further among the plaintiffs themselves has not been addressed in any way.
Oh yeah, I don't want you to misconstrue my question though. I mean, my questions are, the premise of my questions is that the 2006 tax return doesn't just settle the issue, which is I think what the district court said.
I'm sorry?
The 2006 tax return declaring a loss settled the issue for the district court.
That's correct, and that was wrong as a matter of law. Under Cruz, and Your Honor, I'd point you to Medesa versus SRI, which held that which held that Article 104 is a procedural tax provision. Its aim is fiscal, and if you contrast that with an employee's inalienable, intangible, fundamental rights to profit sharing. These are rights that the employee itself can't waive. They're the rights that I think both experts on both sides agree that are most protected by Ecuadorian law. It's clear that, contrary to the district court's holding, Article 104 just doesn't make tax returns dispositive.
I do have one question about calculating a company's obligation to share profits under Ecuadorian law, and I confess I am not an expert on Ecuadorian law. Right. Too bad. And this may be much ado about nothing, but I just wanted your take on it. There seems to be a bit of a textual difference, kind of some linguistic kind of drift between the translated documents that isn't present in the original. And I'm talking about both the Constitution and the Labor Code. So they both purport to derive from this phrase, utilidades liquidas, but so that's the phrase in the original Constitution and the original Labor Code. But the translated documents, even though that underlying term is the same, the translated documents use different terms. So the Constitution uses net profits, and the Labor Code uses realized profits. And I don't know if the translator was trying to communicate something more subtle by choosing two different constructions of the same underlying term. So what, if anything, should we make of that linguistic kind of drift?
Your Honor, I think Your Honor is probably right. There are subtle linguistic differences in both experts' translations, but I don't think that linguistic drift really, I don't think it's pertinent to the resolution of this case on appeal. The fact is, or the law is, that Article 104 is not dispositive. Tax returns are not dispositive. The question of whether this is realized profit for 2006 or net profit for 2006.
You know, that seems kind of important to me, although I don't speak Spanish like Judge Willett does. But the word realized, the phrase realized profits is the one that Judge Hughes uses. I'm assuming, although I'll verify this, that that is the phrase in the, what is it, Article 97 of the Ecuadorian Labor Code, realized profits. And then oh, here, I'll try some Spanish, the finiquito, right? Did you catch that? That says, the only matter that shall remain outstanding and unresolved between the parties is a calculation payment of legal profit sharing percentage, if any, which may be due during the 2006 fiscal year. Now, that's a contract between the parties, right? So why wouldn't you say that even assuming the settlement sort of can be traced back to 2006, these were not due during the 2006 fiscal year?
My response to that would be, regardless of whether there's a temporal element in the settlement agreement, there's a statutory duty, and we brought a statutory claim. And while the breach of contract claim turns on the same answer to the same question as the statutory claim, I think the primary claim has been the statutory violation, and I frankly don't think Oxy has raised any issue substantive besides the overarching question with regard to the breach of contract claim. But what is clear, and I will just point the court to one more provision, and that's Article 326 of the Ecuadorian Labor Code and Article 7. And the reason I want to bring those to the court's attention is because those make clear that embedded in the Ecuadorian Constitution is a pro-worker principle that states, if the court has any ambit or any doubt as to the ambit of Article 104 as it relates to Oxy's profit-sharing obligations, under Ecuadorian law and Ecuadorian interpretive principles, the court should construe Article 104 in a way that is most favorable to the worker. So Oxy can't hide behind Article 104. It can't hide behind its 2006 tax returns.
You know, so let me just verify this. There's nothing in the Labor Code that speaks to this particular issue, meaning a settlement in the future, and that can somehow be referenced back to a particular year of profit sharing. There's nothing in the Labor Code that specifically speaks to that?
Not to that
No.
specific.
Okay, I mean, I didn't think so. And there's no, but you mentioned the Cruz decision, but there's no decision, controlling decision under Ecuadorian law that speaks to that particular issue.
There is no controlling decision under Ecuadorian law that I'm
Settlements.
aware of that speaks to a settlement agreement that was
Okay,
reached after.
well, I guess that's why we're here, yeah, okay.
But there is the overarching principle that makes its way through the Constitution, through the Labor Code, and through the case law that establishes that tax returns aren't dispositive. Thank you.
Mr. Dunbar, thank you. You've reserved 5 minutes for rebuttal, and we'll hear now from Ms. Gailey.
Thank you, Your Honor, and may it please the Court, Lauren Gailey with my co-counsel Paula Hinton for the Occidental defendants, who I'm going to refer to interchangeably, even though they're not, as we spelled out in the briefs. Your Honor is quite right to note that the seizure of the assets is generally relevant to what happened here. So on May 16th, the offices were seized. Then on May 17th of 2006, the oil fields themselves were seized. That's going to add up to a bad year. And indeed, they eventually got $979 million back, but they had lost $770.
Is it true that the 979 is supposed to represent, I hesitate to say profits, but let's say revenues, for not just the remainder of 2006, but also subsequent years, or is that contested?
No, Your Honor, that's not a safe assumption. It is contested.
Okay.
But first of all, I wanted to say that you correctly recognize the distinction between revenues and profits. Although the plaintiffs take issue with the district court's use of that term, there's
Well, it's just common sense. I mean, you've got money coming in. That may or may not be profits. It depends on whether it exceeds your costs, right?
Exactly, Your Honor, yeah. For accounting purposes, revenue is calculated quite differently than this damages award, which actually that's one of the most important reasons that it's not a safe assumption. There are actually two. One is that the settlement is not a proxy for the arbitration award. The arbitration award was for $1.1 billion plus interest. The settlement was for quite a bit less than that. And if you want to see how much less, that figure is sealed, but it's at 1.1 of the settlement agreement at page 1320 of the record on appeal. And in essence, the settlement mooted the arbitration award.
Could you say that again? Because I've been dealing with figures like 1.7 billion was the original award, reduced, and then there was a settlement.
Correct. Okay,
I don't want to say now I'm worried about saying something that's been sealed, but that couldn't have been. There's a sealed amount that represents a settlement?
The percentage by which Oxy agreed to reduce the arbitration award is sealed still.
Okay.
But yes, you're right about the numbers, and it's probably pretty easy to reverse engineer what that percentage is. But lost profits as a damages calculation is not the same as lost profits in an accounting sense. The actual measure of damages was fair market value of the concession, so what the concession would have been bought for by somebody who could pay for it. And then discounted cash flows tries to predict what that would have been, taking into account such factors as, say, what the price of oil might have been at any point. Profit for accounting purposes, revenue less expenses. It's backward looking, it's certain, it's measurable. And that's why the basis that Articles 97 and 104 use, realized profits, promotes certainty and finality. And so getting back to the textual considerations that were raised, pro-worker policies cannot overcome the text. And that's actually codified as well. Canon number 1 of the Civil Code, Article 18, which addresses statutory interpretation, says, when the meaning of the law is clear, the The literal letter of its terms shall not be disregarded under pretext of inquiring into its spirit. So that'll sound familiar. That's one of the things that the civil code and our common law system do have in common. And so Article 97 requires the employer to allocate 15% of its realized profits.
Is that the relevant language from Article 97, realized profits?
Yes, Your Honor. And what that means is actually received. And then Article 104 directs to the tax return to find out what that number was. What was the actually received, actually reported number? And the plaintiffs conceded. In fact, their expert, Dr. Kadena, concedes on at least 4 different occasions. This is in the record on appeal from pages 275 to 77, that the basis for profit sharing is the declaration made by the employer to the tax authorities on its annual balance sheets. And what that does, the importance of 104 focusing on those tax returns, is that Ecuador's code has built certainty into its profit-sharing provisions based on realized reportable profits rather than an ad hoc inquiry into what retroactively might have been. Think of a hypothetical that went in the opposite direction. That's probably quite common, where the company is the defendant in litigation. And years down the road, they lose money in a lawsuit. Then what happens? Could their profit for the years in which the suit arose be retroactively readjusted downward? Would the profits have to be clawed back from the employees if they were shared? Obviously, that can't be. And that's why determinations about where to look, how to administer this provision, how to balance the interests of the workers, and the need for certainty to ensure that companies can do healthy business in Ecuador, it was baked into the code, which gives these straightforward instructions as to where to look and how to calculate. I also wanted to address the Cruz case for a second, which is, this situation is quite different than in our common law system. As the plaintiffs acknowledged, there's no such exception in the code. It's just the Cruz case. But as your honors know, precedent works quite differently in the civil system, where Ecuador uses jurisprudence constant. So it requires.
I studied law in Louisiana, and we studied that too. It was in French though. It wasn't in Spanish, but it was the same principle. I get it. Precedent isn't quite as, it's not stare decisis.
Exactly. And in Ecuador, it takes 3 decisions, and this is in the record, by the way, this is in the arbitration award at pages 16, 18 to 19. It requires 3 decisions on the point of law specifically. And as I believe Your Honor suggested, the Cruz case doesn't apply here anyway, because the employer there failed to file a tax return. If you look at what the expert report said about the circumstances under which falsity might arise, it's quite different from this. It's failure to file, falsity, but it's proven. Definitively established as false implies that someone did the establishing. Who could that be? Here, the SRI, as you recognized, audited the tax return and it became final. And then later during this litigation, Ernst & Young said that it was done correctly. And that was undisputed. So that should put to rest finality. And
Cruz, just to remind me, Cruz is a profit-sharing case, right? I mean, in other words, determining the amount of profit sharing.
I don't want to verify that that was in fact the holding, but the dictum.
Meaning, just the subject matter of the case. It was a profit-sharing case that had to do with whether a return had been definitively shown to be false. Do we have a translated copy of the Cruz opinion in our record?
I don't recall.
Okay. Well, I mean, we can look.
But I do know, Your Honor, that in the snippet that's provided, yes, it refers to the profit sharing, and that where an employer, in Cruz, what happened was the employer didn't file at all. And so there's no way to know. And here we do know, and what was reported was a loss. So I also wanted to, in closing, unless the court has any other questions about these statutory interpretation issues, there's an alternative avenue for affirmance here. The statute of limitations. The statute of limitations in labor cases is 3 years from the termination of the employment relationship, and no one disputes that it generally applies here. The worker's employment was terminated May 17th of '06. The statute ran 3 years later. And so plaintiffs try to get around this fact by saying that the clock started when their claim became enforceable. That is, when the award and settlement started to be paid. That sounds a lot like realized profits to me, which puts the plaintiffs in a catch-22. If the profit was realized in 2006 while they worked for Oxy, the statute of limitations is run. But if the profit was realized in 2015, and again, that's Dr. Almeida Guzman's declaration, they didn't work for Oxy, and they lose on the merits. So, Your Honors, if the court has no further questions, we'll stand on our briefs.
Thank you, Ms. Gailey. We appreciate it. Mr. Dunbar, you got 5 minutes.
May it please the court. 2 quick points on rebuttal. I want to start first by addressing the statute of limitations issue. As Ms. Gailey pointed out, Article 637 tolls the 3-year statute of limitations in accordance with the norms of civil law. The Civil Code, in turn, specifies that the statute doesn't begin running until the right becomes enforceable. Oxy's entire position in this case is that these assets were contingent until they received them in 2016, but that's precisely why their rights did not become enforceable, although they vested earlier on until Oxy received these.
Does Cruz address a statute of limitations issue?
No, Your Honor, it's not. It does not. Or I will say, as far as the portions of Cruz that we have translated do not address the statute of limitations issue. But Ms. Gailey says, well, they're in a catch-22 because that means they have to concede that these were realized in 2016, but I think she conflates the word realized with the word received. Nowhere in the Constitution, regardless of how it's been translated, nowhere in the statutory framework does it say that the profits have to be received in the year that the employee rendered services.
None of the expert reports on Ecuadorian law address that question. What does realized mean?
Well, our expert addresses the question and answers it by saying these were profits realized in 2016 attributable to 2006. But really, when they were received is just happenstance. I don't think Oxy would dispute that if the participation contract was terminated in February and the Republic of Ecuador decided to forego what ended up being a 10-year arbitration proceeding and settle in 2006 for the same amount, I don't think Oxy could dispute that those would be profits that would have to be shared with the plaintiffs, which shows that the only issue that Oxy really has with the profit-sharing obligations is timing, which is completely happenstance. But at bottom, it cannot be disputed that Article 104 doesn't control when evidence exists outside of a tax filing of profit. We provided ample evidence that Oxy received a profit attributable to 2006. The district court ignored that evidence. That was error, and the order granting summary judgment.
Your best authority for, it seems to me, your top line proposition that Article 4 can't be the exclusive way of figuring out what realized profits are. Just remind me, what are your best authorities for that view?
I would obviously say Cruz stands for that proposition generally, and then we have several Ecuadorian legal scholars that have gone beyond, that have recognized that interpretation of Cruz, endorsed that interpretation of Cruz, and recognized the broader overarching principle that when there's profit outside of a tax return, What the 0 in the loss column does not control. Thank you, Your Honors.
Mr. Dunbar, thank you. That's the only case we have on this afternoon's calendar, so we thank you both. The case is submitted, and with that, we'll take a recess.